Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. One of the areas that has confused many in the general community regarding Mr. Koberger's reason to change the complete direction of his defense as he did and go from being a person who his attorneys called at one time factually innocent of the crimes at 1122 King Road is the position on discovery. During the more than 2.5 years that this case was active, there were multiple motions to compel evidence that had been asked for in discovery by the defense. There were hearings. There were filings where the defense asserted that they were not being provided with discovery in a proper manner and or on time. That position continued as late as 6 days before change of plea hearing. I'd like to direct your attention to one of the two final orders that Judge Hippler entered in the case before the change of plea hearing. The order at issue is the redacted memorandum decision and order on defendant's motion to continue. Judge Hippler cites three specific reasons that the defense raised as good cause to seek to postpone the trial that was scheduled to commence in August of 2025. The very first reason is that Mr. Koberger asserts that the volume of discovery continues to pose a challenge to his counsel's ability to timely and meaningfully review all of it. That appears page 1 of that order. If you were to go down to page number 3, here the court writes that the defendant first contends that the vast amount of discovery in this case renders it impossible for the defense team to review the necessary and relevant discovery in a manner that allows for it to be comprehensively integrated into his defense. He further argues, without any support or explanation, that there are a, quote, myriad of issues, end of quote, that continues to arise from the state failing to comply with discovery and expert disclosure deadlines. A continuance, he argues, is necessary for counsel to mount an effective defense, ladies and gentlemen, based on this first reason set forth, that because of the state's behavior, that the defense did not have enough time or the ability to go through all of the relevant discovery in this case. In the second paragraph, page 3, this court rejected this same argument 2 months ago when the defense brought it forward seeking to strike the DP and also impose discovery obligations against the state. And in its order, the court observed that the utter lack of any proof supporting the defendant's accusations of discovery violations by the state. And you'll recall, Judge Hippler noted that defense counsel Ms. Taylor, who had gone out into private practice after being a public defender for a number of years, agreed to take on a second complex and time-consuming DP case after she had already been counsel for Mr. Koberger. This issue of did defense or did defense not have sufficient time to sift through all of the discovery, and there was apparently a lot. It's under seal for the most part to effectively mount a defense. 6 days after this court order denying the defendant's motion to continue the trial, with the first reason given, the defense counsel did not have enough time to go through discovery to properly represent Mr. Koberger, Judge Hippler asked Ms. Taylor, did the defense have sufficient time to review discovery in this case such that Mr. Koberger is now making this change of plea to guilty? Ms. Taylor responded yes. So at what point did this case go from one where consistently the defense said there was not enough time to go through discovery to one where suddenly there was? It is abundantly clear that any attorney does not have the luxury of not being truthful to a judge. It is called the duty of candor to the tribunal. It is in place in every jurisdiction in the land, including in Idaho. Rule 3.3 of the Idaho Rules of Professional Conduct, ethical rules that attorneys must abide by, strict ethical obligation, which prevents lawyers from misleading judges and ensures the integrity of the judicial process. When exactly did the situation with discovery change? Until next time, thank you for joining us here today.